We thank you so much for watching Law School Made Easy at Law School Made Easy 256. And we ask you to subscribe, share, and keep liking our videos. So we want to now look at Section 8 of the Evidence Act. Section 8 creates 4 elements that colleagues must appreciate. These 4 elements. However, in this video, I am going to discuss 3. Then the last one, which is identification, I'll discuss identification in its own video because we have identification parade, we have a single identifying witness, and then we have voice witness. So voice identification. So I'm going to discuss the identification in its own video, where I will tackle the identification parade, single identifying witness, and then the voice identification. And then that will be done in Section 8. In this video, we are going to handle facts that explain and introduce the fact in issue, and then facts that rebut or infer a presumption, okay? And then we shall talk about facts that fix time and place of where the offense happened, which time and place the offense happened, relevant facts. Okay? And then for identification, we shall do it in another video, which will be elaborate about identification. So let's start with facts which explain and introduce the fact in issue are relevant. So Section 8 is telling us that if you look at facts which explain how the fact in issue was brought about, those facts are relevant. If they're introducing something about the fact in issue, those facts become relevant. These facts most times are brought about by way of preparation. They are established by way of preparation. Okay? So, I'll give you an example. If you are handling any matter, let's say any matter, and then somebody tells you, let's take an example of, let's take an example of confessions. If you are confessing to someone, but then we are discussing confession leading to discovery. Now, even when the confession has been obtained by involuntary means, threats, violence, but if it is leading, introducing that there are guns somewhere, now we shall not take that information of the gun as not being serious information. Now that becomes serious information. So this confession has introduced something new, which is actually related to the fact in issue. So there you are explaining facts which explain the fact in issue, and we are saying these facts are in the way of bringing about the fact in issue, or they are presented by way of preparation. So those facts become relevant. Those facts become relevant. So there is a case of Kiambu, son of Chitambo. Kiambu, son of Kitambo. Now, in the case of Kiambu, this man was being charged for uttering a false document. Okay? Now, evidence of that false document was not seen, but they presented evidence of previous dealings of uttering false identification, false document. Okay? Now, when that previous dealing was introduced, now that the trial judge used this as a fact introducing the fact in issue or explaining a fact in issue, and this person was convicted. However, the Court of Appeal ruled that the trial judge erred in law listen carefully, the trial judge erred in law to use that fact simply because time had expired. The doctrine of lashes had gotten the people who had reported. Yes, information was good, was relevant information, and was admissible. There were facts explaining the fact in issue, facts introducing the fact in issue. So if you come and let's focus on the material. If you are accusing me of uttering a false document, but you don't have enough evidence, then you introduce or you explain using my involvement in uttering false document previously. So you are bringing facts which explain the fact in issue. Look at that case of Ara versus Brabin Kosa, where the man was involved in corruption, but prosecution introduced previous dealings. Okay? Introduced previous dealings. So that one, they were introducing new facts to the fact in issue, or they were explaining the fact in issue. So that is what we mean by facts which explain and introduce the fact in issue. Those facts are relevant. Okay? Let's now go and look at the case of let's look at the second one. The second one is that facts which rebut, okay? Facts which rebut or inference or presumption, those facts are relevant. If they contradict or support the fact in issue, they become relevant. Okay? Now, facts of presumption. Let's begin with the case of Abdu Kyagulanyi versus Uganda. It's a 1988 case. Now, in the case of Abdu Kyagulanyi versus Uganda, Abdu Kyagulanyi was a licensed goat seller. That he had a license, he deals in goats. Now, two of the other accused people brought stolen goats to his home. Now, Abdu was found with stolen goats. Okay? Was found with stolen goats. He claims he was in Kampala by the time they brought. However, there was no evidence provided to court to prove that Abdu was in Kampala. So the accused, A2 and A3 were acquitted and Abdu was convicted. The question is, why was Abdu convicted? Remember, we are discussing facts which rebut or infer presumption, assumptions, or inferences. Those facts become relevant. Now, Abdu did not produce facts to show that he was in Kampala. But remember, he's a licensed goat owner. So we have found these goats with him. So the doctrine of recent possession held him. So there was a presumption, being that he's a goat seller, licensed goat seller. We have found the goats with him. The question now becomes that the doctrine of recent possession. We have found him. So the presumption was not rebutted. So under presumptions in section 8 are facts which rebut or infer the inferences. The doctrine of recent possession works, and the doctrine of the doctrine of last sin. Those two doctrines are very important. Under this, the doctrine of last sin, yasembye kuba nani, he was last with who? So the presumption is the last person he was with could have killed him. It becomes, those facts become relevant. So look, when we come across presumptions under section 8, rebutting and inferring, you focus more on what we are calling the doctrine of recent possession and the doctrine of last sin. Now, the rule is, if you look at the case of Richard Ogola versus R, in that case of Ogola, court ruled that, one, court is not concerned by suspicion, however strong they are. Now, if you fail to link the chain and you link it to the guilt of the accused, if you fail, if there is any breakage of the link of the chain, then the accused will be acquitted. Because courts do not deal with assumptions or presumptions, however strong they are, okay, you must link them. So the case of Richard Ogola is giving us a general rule that you must link the presumptions to the guilt of the accused. Where you don't link it, the accused will be left to go. So I'm saying, under the case of Abdul Kyagulanyi, Abdul Kyagulanyi failed to show that he was in Kampala. So the doctrine of last sin, the presumption, the doctrine of recent possession, the presumption that he's a licensed goat seller and the goats are found with him, he held him and he became a thief. So facts which rebut the inference or which show the inference become relevant and therefore admissible. Okay? So now let's go to the last one, which is facts which fix time and place of whatever has happened become relevant. Now, here we are saying that the time and place. Now, facts which show that this happened at this time, for as long as it is you can show it and prove to court that yes, it was around this time, then those facts become relevant. Then facts that show the place where things happened from. Now listen, when we are fixing places, this happens. The person, the victim, can fix the place, and also bystanders who were there when this was happening. The moment they say they stole, let's say, at Upper Arizona here. They stole at Upper Arizona. And then the askari says, I saw them. It was in Seguku. It was this. Now, fixing time is very deadly. And the courts have ruled that this is very deadly. It must be coming from somebody who was around the scene. Now here, hearsay will not work. It must be from someone who was at the scene. That I was there, I saw them. It was in this place at the roadside. Okay? So, that one also becomes very paramount. So,